Good morning, everybody. Professor Raggio, distinguished guests, colleagues and friends. It is an extraordinary honor to have been invited to deliver this keynote address of this I-Arbitration Conference. I am delighted to have an opportunity to speak to such a distinguished audience in an area of law which is, from the perspective of my home jurisdiction, Germany, a somewhat exotic field. I remember that it was in the end of the 1990s when I was involved for the first time in an Islamic finance issue. It was in connection with a project done in Malaysia. My German clients were presented in the discussions of the financing of the project financing with a Sharia-compliant portion of a loan facility, and I was asked to give some advice. Since then, in our part of the world, little has happened. It appears, however, that issues around Islamic financing are gaining momentum in Germany also. In March 2015, not even 2 months ago, the first Islamic financial institution has been granted a banking license by the German regulatory authority, BaFin. From July 2015 onwards, the Turkish Kuwait Turk Bank AG, with branches in Berlin, Frankfurt and Mannheim, will commence its operations. You may also be interested to know that very recently in Luxembourg, subsequent to a minister's decree of 30th September 2014, another 200 million euro loan with a term of 5 years and in conformity with Sukuk has been issued in October 2014 by the Luxembourg Treasury Services. Luxembourg is the most important player in the area of Islamic financial products in Europe and considers itself as the leading non-Muslim domicile for Sharia-compliant investment structures and issuance of Sukuk. It has assets of some euro 5 billion under management. Some 111 Sharia-compliant funds are domiciled in Luxembourg, and more than 16 Sukuk are listed on the Luxembourg Stock Exchange. It is, though, a modest figure in comparison to Malaysia, with Islamic banking assets of some 162 billion in 2013 and an expected growth to more than 390 billion by 2018. When I accepted Professor Raggio's kind invitation to speak to you, my initial topic was Sharia disputes beyond banking. I do not exactly know what has happened that at some point of time I was upgraded to deliver the keynote address. I only became aware of what it means when I prepared the talk and looked it up in Wikipedia. I was shocked, to be frank. Keynote speakers are typically prominent and should raise enthusiasm amongst prospective attendees for a conference. With all respect, my distinguished colleague and friend Sundra, this is too much of an honor. I'm neither prominent nor a legal Steve Jobs who makes the heart beats by simply hearing his name. And my dear audience, please forgive me if I do not meet these expectations. I can only promise you that I shall do my best in the next 25 minutes to address some issues which crossed my thoughts and legal thinking when I was involved with aspects of Islamic law. I cannot give you an in-depth study and understanding of the legal institutions of Islamic law and finance. My aim with this talk is to give you a personal perspective on some aspects of Islamic law, its application to civil and commercial matters, and enforcing subjective rights resulting from the respective legal relationship. I shall first share with you some more general aspects before I shall take a closer look to the 2013 KL I-Arbitration rules. Islamic law belongs to the family, as we comparative lawyers call it, of the so-called religious laws, which in the Western world govern the personal law of Jews for some 4,000 years, and those of Christians and Muslims for almost half that time. There have always been private international law issues or conflicts of competing personal religious laws in matters having a cross-territory element. As Ronald Graveson has rightly pointed out, the separation of law and religion in the Western European civilizations has resulted in a two-steps approach, the first being the reference to a territorial system based on a non-religious link, and the second being a further reference within the territorial law so chosen to whatever religious rules it may permit. It seems to me that Malaysia has adopted this two-stages approach. Article 4 of the Federal Constitution states that this constitution is the supreme law of Malaysia. Article 3, paragraph 5 gives power to the Malaysian Parliament to make by law provisions for regulating Islamic religious affairs and for constituting a council to advise the Yang di Pertuan Agong in matters relating to the religion of Islam. Moreover, under the Constitution, Islamic law is a matter falling within the state list, pursuant to which the state legislators have been permitted to make laws in personal and family matters, such as succession, marriage, divorce, and the like. In contrast, the so-called federal list of the 9th schedule of the said Constitution sets out the matters that fall under the jurisdiction of the civil courts, which includes inter alia, contracts, mercantile laws, and all banking matters. As regards judicial powers, Article 121, para 1a of the Constitution excludes the jurisdiction of the 2 high courts of Malaya over any other matter within the jurisdiction of the Sharia courts. Whilst there may be some uncertainties as to the scope of determining whether the civil courts or Sharia courts have jurisdiction, Harding has rightly described the question of the relation between the civil legal system and the Islamic legal system as a crucial question in the continuing development of Malaysian law. It should also be noted, and Professor Racho mentioned that in 2003, a special court called the Muamalat Division of the High Court of Kuala Lumpur was established to hear Islamic banking cases. Since then, all these cases must be registered in the Muamalat Division of the High Court. Turning now to the area of arbitration, it was in March 2007 when KLRCA has put into operation the rules of arbitration for KLRCA Islamic banking and financial services. These rules, however, only applied domestically and were restricted to business transactions and business arrangements involving financial instruments and commodities as defined under the Central Bank of Malaysia Act 2009 and the Capital Market and Services Act 2007. The 2013 KLRCA I-Arbitration rules, which form an important subject matter of this conference, have a broader scope of application and are designed to apply to domestic and international disputes arising from commercial transactions premised on Islamic principles. The Islamic Banking Act 1983 and the Takaful Act 1984, which were repealed by the Islamic Financial Services Act 2013, show that Malaysia has recognized the need of a statutory transmission belt in form of an act which was passed by Parliament to apply Islamic law and enforce it within its territory. Also, for Muslims, the divine law is timeless and always in application. As a modern state, Malaysia has recognized and implemented legal structures to administer the application of Islamic law. At its origins, Sharia refers to all Islamic laws which are derived from the Quran and the Sunnah, which is the Prophet's divinely guided lifestyle. Over the centuries, different schools of law have been developed. The freedom to interpret Islamic laws by qualified jurists and scholars has led to a myriad of differences of opinion, which were influenced by the characteristics of society's customs and other aspects of the society, as it has been explained by the Honorable Justice Dato Haji Muhammad Sawawi bin Saleh in a well-reasoned judgment of the Kuala Lumpur High Court. So far, there was only one attempt in history to frame the rules of Islamic civil and procedural law in the form of a codified act. In the Ottoman Caliphate, during the years from 1869 to 1876, a digest of legal rules and principles has been set into force in the form of an act, those principles of Sharia law which govern ordinary civil rights and obligations. Also, the so-called Medyele is a codification exclusively based on the Hanafi school, though considering minority opinions, In Malaysia, it has been suggested in doctrine to consider the Medyele as an attempt to codify Islamic law, which commands respect in academia and for the purpose of learning and appreciating Islamic law in general and Islamic law of commercial transactions. The Medyele is particularly interesting to the arbitration world also. In its 16th book on judges and judgments, Title 4 is dealing with arbitration. Article 1841 expressly allows arbitration in questions of law relating to obligations and to things. Article 1850 even addresses a fairly modern concept of the interface between mediation and arbitration by allowing the parties who have appointed arbitrators to decide their case to give to the arbitrators also power to put an end to the dispute by means of a compromise. I have tried to explain to you that in order for Islamic law giving a legal subject an enforceable right over another legal subject, it is necessary that a particular system of law offers a machinery for the administration of justice and the enforcement of an individual right. In order to determine in a cross-border context the territorial system of law governing the legal relations of the parties, this is normally done by way of a choice of law clause, or in the absence of an express or implied choice, the now and then difficult search for a system of law with which a contract is most closely connected. I am sure that you are all familiar with the glorious Sharia case tried before the English courts, where the choice of law clause read as follows: subject to the principles of glorious Sharia, this agreement shall be governed by and construed in accordance with the laws of England. The English Court of Appeal adopted a fairly practical solution by avoiding a decision of unknown Islamic law and determining the validity of the contract and the obligations resulting therefrom to be decided to English law only. A similar case was decided by the English High Court in the investment Dar company KSCC and Bloom Development Bank SAL, where the subject matter was a master Bacala contract and certain individual contracts made thereunder. The contracts were governed by the laws of England, but the dispute of the parties rests upon matters of Sharia law. Appellant was a Kuwaiti company which in its memorandum had an article pursuant to which the objects for which the company was established shall be Sharia compliant, and none of the objectives shall be construed and interpreted as permitting the company to practice directly or indirectly any usury or non-Sharia compliant activities. It follows from the reasons of the judgment of the High Court that the High Court had expert evidence before it on the issue of applicable Sharia law. As the appeal was an order from granting summary judgment, the Court of Appeal did not take a decision to determine conflicting expert evidence on the question whether the terms of the Wakala contract in question were a device to allow the payment of interest under another guise, and as such a direct practice of a non-Sharia compliant activity. This brings me to the crucial question as to how Islamic law has to establish if a question of Islamic law comes before a court or an arbitral tribunal. As far as state courts in Malaysia are concerned, a matter of uncertainty was the procedural nature of the compulsory reference for the court to refer a Sharia issue to the Sharia Advisory Council for ascertainment, and its ruling being binding on the court. It had been suggested that the relevant sections 56 and 57 Central Bank Act Malaysia are unconstitutional as they usurped the judicial power of the court by delegating the court's decision-making power in relation to Islamic financial business to the Sharia Advisory Council. It was again the Honorable Justice Dato Haji Muhammad Sawawi bin Saleh who stated that a reference to the Sharia Advisory Council and the ruling then issued is an expert opinion of Islamic financial matters. In the further matter of Tan Sri Abdullah Khalid bin Ibrahim and Bank Islam Malaysia Berhad, the same Honorable Judge held that the Sharia Advisory Council is required to ascertain the applicable Islamic law on the Sharia issue in question, and that upon ascertainment of Islamic law, the court would then have to apply it to the facts of the case before it. How is this matter dealt with in arbitration? The 2007 KLRCA rules required an arbitrator to refer a point of law related to Sharia principle to a Sharia expert or counsel to be agreed between the parties, and such expert was then required to form an opinion on the Sharia aspect. The practical problems of such reference are obvious. What happens if no such agreement could be made between the parties? The 2013 KLRCA I-Arbitration rules have done away with that difficulty to some extent. I shall take a closer look to this newly designed rule, as it is an innovative stop indeed to offer a practical solution for settling disputes arising in connection with Sharia-based commercial transactions. Whether it is simple, Sundra, I'm not sure about it. I always also like this so-called KISS principle, keep it simple and stupid, but that I cannot say from Rule 11. Rule 11 requires an arbitral tribunal to refer a matter of any Sharia issue in the Islamic financial business to the relevant Sharia Advisory Council or Sharia expert, under whose purview the Sharia aspect to be decided falls. In that context, it should be noted that in Malaysia, the Sharia Advisory Council of the central bank is the apex authority for the ascertainment of Islamic law in the Islamic financial business. It consists of prominent Sharia scholars, jurists, and market practitioners who have vast experiences in banking, finance, economics, law, and the application of Sharia, particularly in the areas of Islamic economics and finance. Pursuant to Section 29, Para 1, Islamic Financial Services Act 2013, the central bank may, in accordance with the advice or ruling of the Sharia Advisory Council, specify standards on Sharia matters in respect of the carrying on of business, affairs, and activities by an institution which requires the ascertainment of Islamic law by the Sharia Advisory Council and give effect to the advice of or rulings of the Sharia Advisory Council. A second Sharia Advisory Council has been established with the Securities Commission Malaysia, which is responsible to give advice on matters pertaining to Islamic capital market. In October 2010, the second edition of the Sharia Resolutions in Islamic Finance, which is a compilation of all Sharia resolutions made between 1997 and 2009, by the Sharia Advisory Council has been published as part of the commitment of the Malaysian Central Bank towards the development of the Islamic finance industry. With that, I think, Malaysia has established the necessary infrastructure for the proper administration of important areas of Islamic law. Coming now back to Rule 11 of the 2013 KLRCA rules, only in the event that there is no specific Sharia council or expert, the Sharia council or Sharia expert must be agreed upon by the parties. New is the subsequent default provision. In the event that no such agreement can be reached, the arbitral tribunal may appoint an expert in conformity with Article 29 UNCITRAL arbitration rules, which deals with the tribunal-appointed expert. There is a distinct difference between Rule 11 and Section 56, Para 1, Central Bank Act of Malaysia, 2009. According to that statutory provision, the arbitral tribunal shall refer any Sharia aspect to a Sharia Advisory Council or Sharia expert. It has no discretionary powers in that regard. The term shall reduces the discretionary powers to zero. In contrast, the term may, as used in Rule 11, Para 1, allows some flexibility to consider non-financial Sharia issues or different legislative solutions adopted by countries other than Malaysia, which may be applicable as the proper law of the dispute before the arbitral tribunal. But if the laws of Malaysia are the proper law to be applied by the arbitral tribunal, then the reference to the Sharia Advisory Council or Sharia expert is a must. Also, not expressly articulated in Article 11, Para 1, the arbitral tribunal is well advised to consult with and seek the assistance of the parties and their counsel in formulating the questions and issues to be referred to the Sharia Advisory Council or the Sharia expert. The same applies to the preparation of the reference, including the relevant facts, to the extent that they are not in dispute or have been agreed by the parties, as stipulated in Rule 11, Para 3. Rule 11, Para 2, A and B speak of a decision of the Sharia Advisory Council or the Sharia expert. Yet it seems to be clear that a proper construction of the term decided in Rule 11 means ascertained. As follows from the second half sentence of Rule 11, Para 8, it is solely the arbitral tribunal which decides on the application of a ruling of the Sharia Advisory Council or an opinion expressed by the Sharia expert to the set of facts before it. This is in conformity with the principles articulated in the Tan Sri Abdul Khalid bin Ibrahim and Bank Islam Malaysia Berhad case, to which I made reference earlier. Rule 11, Para 4 requires the arbitral tribunal to adjourn the arbitration proceedings until the ruling has been given upon the reference. But the arbitral tribunal retains the authority to proceed with other matters to be tried in the arbitration, which are independent of the said ruling. Although the term deliberate seems to suggest that only the internal process amongst the arbitrators is concerned, a proactive approach should be taken by the arbitral tribunal to proceed in suitable cases with the arbitration in respect of issues in dispute before it which are not related to the Sharia aspect of the matter, such as the continuation of the evidentiary process by hearing witnesses. Rule 11, Para 5 seems to suggest that the parties have no right to make submissions or present their case before the Sharia Advisory Council or the Sharia expert. The argument that this may violate the parties' rights to be heard has been rejected in the Mohammed alias bin Ibrahim and HRB Bank Berhad case, where it was held that as long as the Sharia Advisory Council has not published its procedure, no party can show that it had a right to be heard and how it is to be exercised, and that accordingly no violation can occur. The concept of natural justice, that's where the words of the courts, do not require for every case to make a provision for a hearing of the parties. Let me remark that this fairly strict approach may have to be adjusted in arbitration, as the parties have a legitimate interest in transparency of the procedure. They are those who have appointed the arbitrators, in contrast to a judge. A similar area of concern in arbitration arises from the fact that the parties have no explicit right to request the presence of the Sharia Advisory Council or the Sharia expert at a hearing before the arbitral tribunal to answer questions on its ruling. This distinguishes the ruling of the Sharia Advisory Council or the Sharia expert from a typical expert opinion introduced in arbitration proceedings by way of an expert report prepared by a party-appointed expert or a tribunal-appointed expert. The ruling, therefore, must be qualified as an expert opinion sui generis, as we old Romans say. This reminds me of a dictum in connection with the qualification of questions of foreign law, where it was held by Justice Kearns in the famous Parkasho and Singh case that the question of foreign law, also a question of fact, is a question of fact of peculiar kind. I will not go into the question whether there is any foreign law for an arbitral tribunal, because that would lead me too far, but it can be also discussed. Yet it may be wise for an arbitral tribunal to issue on a case-to-case basis suitable directions in line with the procedure specified in Article 29, para 4 and 5, UNCITRAL rules, in particular in the event that a Sharia expert has delivered a ruling. Rule 11, para 6 sets a time limit of 60 days from the date of the reference for delivery of the ruling. A default provision is articulated in Rule 11, para 7, giving authority to the arbitral tribunal to proceed to determine the dispute and render its award based on the submission it has before it. Sentence 2 of the said rule reflects agreement of the parties that the validity of an award shall not be affected by the unavailability of the relevant Sharia counsel or Sharia expert's ruling. It remains to be seen whether party autonomy in the field of arbitration may oust the compulsory reference to the Sharia Advisory Council under Section 56, para 1, Central Bank Act, in the event that Malaysian law is the proper law of the dispute and a ruling is not communicated within a reasonable period of time. Given the widely acknowledged reputation of KLRCA in Malaysia and elsewhere, the willingness to further enhance the arbitration process on the basis of consensus ad idem between the parties and the principle of volenti non fit in iuria may apply to that default situation, but we will have to see what the courts will do with it. Finally, Rule 11, para 8, limits the effects of the ruling of the Sharia Advisory Council or the Sharia expert to the issue or question submitted to them by the arbitral tribunal. There is accordingly no judicial function of the relevant Sharia Advisory Council or the Sharia expert to entertain a discovery of facts or any other form of evidentiary process, nor is there any power to apply the ruling or to formulate any decision relating to any fact of the case. The decision-making process itself remains within the exclusive domain of the arbitral tribunal. Why is the qualification of the ruling of the Sharia Advisory Council as expert opinion on Islamic law so important in the area of international arbitration? Professor Racho has already mentioned it. I think also that it follows clearly from the need to seek the support of the state courts to make an arbitral award enforceable. Under the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards 1958, the qualification of the ruling of the Sharia Advisory Council as expert opinion on Islamic laws is of utmost importance. Recognition and enforcement of an award can be refused if the arbitral tribunal delegates its power to render its decision to an expert. As follows from the persuasive approach adopted by the Malaysian state courts, an arbitral tribunal seated in Malaysia, which has to apply Islamic financial law and to refer a Sharia issue to the Sharia Advisory Council, retains and has to duly exercise the power and authority vested to it by the parties' agreement to arbitrate. The same applies to an arbitral tribunal seated outside Malaysia if the proper law of the dispute before it is governed by the laws of Malaysia. The compulsory requirement that the arbitral tribunal has to refer a Sharia issue to the Sharia Advisory Council to obtain a ruling on the applicable Islamic law and to take into consideration any published ruling of the Sharia Advisory Council does in no way prevent and should not prevent the arbitral tribunal from exercising its powers to determine and adjudicate the dispute before it. With that, let me close. I thank you very much for your kind attention. I wish us all a successful conference with enlightening talks, thrilling discussions, interesting sessions, and fruitful networking activities. Thank you very much.